to the Lateral Lawyers podcast. We're in a bit of a rush this morning because Facebook, in its esteemed wisdom, only lets you have 8 minutes from 10:30, so we don't keep our huge viewership waiting. So it's a bit of a sprint, wasn't it,
Got to
Liam?
feed the streets. Yeah, exactly.
Yeah, but we're here and we're on schedule to deliver yet another rousing expose in the law around restraints of trade.
Mm.
So without further ado, I'll just open up a little bit of discussion around that, and then Liam's going to hit it out of the park with a little précis on the sort of the general position and some practical tips on how to negotiate that. Every single one of you watching either probably has been or will be at some point wanting advice or be in the middle of a, dare I say it, dispute around restraint of trade. Huge area. Obviously, the principle, for those of you who don't know what it means, is that it's a contractual agreement that in consideration for you agreeing to do something with another party, you will then refrain from doing that thing after your employment or your business sells. And the general position is that they are a lot less enforceable than
otherwise
the
think,
people, attempting to get to enforce them or threaten to enforce them would have you believe. So without further ado, Liam's going to take away sort of a general précis on the position, the general position, and then some sort of tips around how you can deal with that.
Yep. So these restraints of trade, they're almost in every employment agreement and basically business sales as well. And so what they essentially are doing, like Shane said, is in consideration for you or us maybe paying your salary or doing these jobs or us buying your business, you agree to do what is set out in that contract as the restriction. Now, interestingly enough, the courts are actually kind of slow to enforce these. They are of the view that they're not really in the public interest, and so they are sort of, in a way, what is termed prima facie unenforceable. Now, that may somewhat overstate the case. It's not like they're never enforced, but they are definitely something you need to be aware of. And it turns on really reasonableness. That's the real name of the game. Courts don't like to enforce them because they're against public interest. If someone could just basically say you're no longer allowed to be in the workforce in this area or something like that. So it's about reasonableness, and it's reasonable between the parties and whether or not it's in the public interest. And so in the employment context, what that really means is that the employer basically has a proprietary interest. So that's whether it's an asset or know-how or the way it does things, and it's saying, because of your involvement with our business, these may have come across your desk, or you may be intimately aware of them now, and you now have an asset that is that we're keen on obviously protecting and looking after. So you can't just sort of take that client list and run out the door and poach all those clients, or capitalize on the know-how that you've sort of gleaned from your employer and run off into the sunset and start your own business. So those sort of the what it's really trying to protect. But as I sort of said,
haven't the courts been slow to or reluctant to enforce restraints where there hasn't been a specialist occupation or
as I said, it's the name of the game is reasonableness, and so there's all of these things to sort of unpack in and around that. So it's is the length of time reasonable? Is the area unreasonable? Is what is actually said that you're not allowed to do, is that in of itself reasonable? And is what the employer or the purchaser trying to protect, or what they consider is an asset they're trying to protect, is that reasonable in of itself for them to do that? And so it's things like, if you're in a very senior management position, and by that you're usually going to have a lot more information coming across your desk, which is going to be a bit more to the point of trade secrets, or very fundamental to the way a company is going to be run. Whereas if you're a very junior level, just maybe a salesperson just picking up a phone, you're not going to have that. You're not often going to have that sort of information coming across your desk.
The general sort of That's exactly right. And so the general theme of inquiries to us in this regard are either from employers who are, or yeah, we'll talk about business restraints later, but employers who are perhaps overzealous in their belief that they can restrain someone without looking a bit further into, like Liam just said, then the particulars of that person's job description, or whether they actually had in their grasp any type of actual proprietary interest. Just that person having been good at their job and knowing how to run a business well, if they've been in an operational type position and they're worth their weight in gold, well, the answer to that business owner might be, well, sorry, but perhaps you might have looked after them and paid them a bit more, or better, or just generally enticed them better. Or sometimes it's just like that. That's life. You can't. But just to answer that question, you to that when the client comes to us, quite often the advice is, well, I'm sorry, but we just don't see how there's anything of a sort of special or out of the ordinary nature that a court is likely to.
You can't, an employer or a pitcher, they can't penalize you for basically having an acquired knowledge and skills as the job you've done for 5 or 6 years. What they can do is you using those skills along with, or somehow adapting and incorporating, as I sort of said, that proprietary interest that employer has, or something like that. You can't sort of be, as I said, penalized for basically, as Shane said, being good at your job.
Yeah. And Liam, do you just want to get into, just to make this as practical for people as possible? We understand it as a little bit highbrow, this type of stuff, as practical as possible, in terms of talking about situations where a party may attempt to go apply for an interim restraint, the costs around that, an interim injunction, the costs around that, and the what we talked about earlier when we're acting for a client about the practicalities around whether they can be enforced or modified and enforced, and how that can have a big impact. That's a very important bit of information for a client to be aware of, in terms of whether they either seek to enforce an interim injunction, or whether to continue to say be employed by a new employer in alleged breach of the restraint. That was a mouthful, so you got my gist.
I would say, just the first thing I would say to that is that often you'll find that these restraints are usually utilized more as just sort of a scaremongering tactic. They say, hey, look, this is what's going to happen to you. But the practical reality is that these people, if they actually really do want to enforce these, they're going to have to be pretty committed to spending quite a bit, because it's basically they'll need a court order, getting an interim injunction, basically, and that would say, as the court order, saying you're not allowed to do what the restraint is. So that inherently in of itself is a pretty substantial step, as opposed to just getting your lawyer to send off a few emails saying, hey, by the way, you're in breach of this restraint. That's definitely front loading a bit of cash to your lawyer and starting court proceedings. So that's what I would say in terms of often with these things, is a scaremongering.
And
tactic.
What can be some of the issues? I know it's a esoteric point, but I think it's such an interesting, intriguing one. What are some of the issues with, say, trying to enforce trying to get an interim injunction?
So they have to basically prove to the court in the first instance that there is an arguable case here that restraint would be enforced wholesale. So that means that they have to show to the court that basically this restraint is so reasonable that the court is going to go, yep, that's fine, and just enforce it as is, or it's that it's going to be enforced even without modification, because the courts do have the powers to modify and read in certain things to the restraint. But even if they can't prove that, the courts will be slow to grant that injunction on that basis.
So it can be difficult for an employer to enforce a restraint which needs to be modified. It can be difficult for an employer to obtain an interim injunction where a restraint would have had to be modified to be enforced. That's right.
Yeah, exactly. Because the court doesn't want to, as I said, the court doesn't want to really grant these unless it's really obvious that they can and have to. So even if it may transpire that there is a potential that it could be modified. Even if that is the case, they will just take the conservative approach and say, no, you can't have that injunction because it might need tinkering with, really.
And the policy reason behind that is that if an employee who is having these proceedings for an interim injunction brought against them was to be restrained early on with that interim injunction, and then it later transpired that at the appropriate forum to test whether or not the restraint could be modified and enforced, in that intervening period, they would have lost potentially their new job and their employment, and other, consequential losses that flowed from that. And it would be unfair to restrain them prima facie before, or fancy legal words for prematurely, before the court could actually test the substance of whether it was fair or not. So that's, good for people who are being pursued by a perhaps relentless and overzealous employer in that regard, but also good to know for employers who are actually seeking to enforce restraints of trade as to the foibles or the potential roadblocks they could have with a restraint, even though their lawyer that drafted it, I'm sure, did it with the best of intentions to try and protect them as widely as possible, can actually work against you to have an overly broad restraint in the first place in terms of the practicalities of enforcing it.
Yeah, that's often the case with these things. They're normally in, a classic lawyer approach is to just try draft things as wide as possible to give whoever their client is the luxury of choice, basically, to choose in between the parameters of where they'd like to go. But in this case, it's almost to your disadvantage to really try catch as many things as possible.
Yeah, and they'll try and put these clauses in, like in terms of obviously severability, and if it can't be enforced, it will be preserved to the extent it's modified. But I mean, that's all very well, but practicality that can be different. Just before I wrap up, because we don't want to go on forever on it's a beautiful, smooth Friday morning out there as we look out the window of our Hobson Street offices, and it's Liam and I tried to schedule in a golf game, and then Luella yelled out that we've had a meeting at 2:00, which is unfortunate. And I was thinking, can we get away with doing it from the golf buggy? But given the importance of this particular meeting, I thought probably not. It's a bit of a stretch even for us. So it looks like we're going to be landlocked for the afternoon.
Yeah, as tempted as I was to have the Skype background be, I could just take a photo of this and just make it the background.
So that's not a bad idea.
That's why you pay me the big bucks.
That's why I do. But just before we move on into not greener pastures, but the illusion of greener pastures, we just want to talk a little bit about the distinction between restraints in the employment versus sale of assets, such as a business context. Liam, what's the general distinction as to why these are can be treated quite differently in the courts?
That's the thing again is the public interest, really. Whereas in the employment context, the courts are saying, really, we don't want people to basically be shut out of the market they've been working in, or I don't want you to be shut out of the market that you've been working in simply just because you've been employed at a place. But the landscape's a little bit different in terms of when you're selling a business, because that's really just almost a private agreement between you and someone else. And so the public interest doesn't really have too much of a bearing on what you essentially agree in consideration for $2 million for your, golf cart business. What you agree in exchange for $2 million, what you agree to do, i.e. not set up another golf cart business within 6 months. Yep. So those are often leaning more to be enforced. Yep. Obviously, there's a whole raft of other of reasonableness factors that still need to be taken into account. But the crux of it, in terms of the distinction between employment and the commercial realm, in terms of buying and selling businesses, is that really the courts are more willing to say, because you have negotiated for this, people have usually got independent legal advice on this. There's obviously a large amount of money can obviously go forward and back, that they'll lean towards enforcing that restraint more readily, or at least longer restraints, or restraints which are wider than normal because of that distinction.
And the primary policy reason in layperson's terms for that is, like Liam said, unlike the employment context where they don't want to restrain people from a public policy perspective from earning a living, and they want to encourage a free market. When someone, when all their know-how, trade secrets, and just being really skillful is able to derive a create a really good business and then sell that at a multiple,
Mm.
for example, 3 times revenue to use a relatively primitive, 3 times EBITDA to use it can be 3 times revenue depending on the industry, a relatively primitive formula. What you're essentially saying is, I need to restrain you, because if you came back and competed, you would potentially erode some of the value in that business, and I can't have you coming in, because that would derogate from the promise, so to speak, of the future revenue streams that I am paying for in that multiple. That is broadly the reason why the court is much more likely or willing to enforce a restraint in the business, in the sale of business context. It's a it's a much less troublesome conundrum for a judge to get their head around, to restrain someone who's received good money for something that they could erode after the parting or the exchange of money for the asset.
Especially when that goodwill or intellectual property value of that transaction is really high.
Particularly then. Yeah. But it even could be in a really, like in a much smaller business sale, for example, a bar. If you have a bar and then a guy sells a bar and has no intention to get back into the bar industry, goes and buys something like a supermarket, and then decides he's going to come back on the same block that he had sold it to another
site,
another joker.
You know what? Why not there?
Then that's so it could apply to any kind of business, large or small. The question is that person, by competing after selling the business, potentially eroding the value of the consideration paid for? If the answer is yes, then you've probably got a problem on your hands. So to sum it all up, Liam, don't take them too seriously. Don't take them too lightly. Get proper legal advice, because there are a lot of peculiarities and a lot of nuances to the particular situation, and you just need good counsel behind you, or us, and they can steer you in the right direction. So have a great Friday, and we look forward to the now regular Friday morning blat from the lateral team. How do I shut this down? Because I'm full screen. Here we go. Right.
Rock and roll.
Talk to you later.